Does the federal government recognize trade secret protection at all?
Yes, the federal government does recognize trade secrets. There are statutes that involve it. However, there is no particular filing procedure with the government or the United States Patent and Trademark Office regarding trade secrets. Rather, each state has their own set of rules and statutes regarding trade secrets.
How do I mark something trade secret?
You do not typically mark anything as trade secret if you're disclosing it to the public. The whole point of a trade secret is that it's confidential. What you need to do to establish a trade secret is to take measures and certain precautions in order to establish that it is confidential.
How do I decide whether to patent something or to keep it as a trade secret?
There is a fine line between patents and trade secrets, and they sometimes merge a little bit. If you feel that you do not want to disclose the inner workings of your invention, then you should maintain it as a trade secret. However, if you do file a patent for something, you have to realize that within 18 months from the filing date, it will be public, and the public can access your pending patent application at any time.
How do I protect a trade secret?
The way to protect a trade secret is not by filing it with any kind of entity. You have to take certain steps and measures to maintain the confidentiality. One of those steps, and this will really vary from state to state, but generally you have to show that the proprietary information you have is confidential. One way to do that is to make sure that all your employees sign confidentiality agreements, that you're labeling things as trade secrets, that you're making sure that only certain employees can have access and others can't. Those are just simply examples of maintaining confidentiality.
What is a non-disclosure agreement?
Non-disclosure agreements also may vary from state to state, and they're going to have little different wrinkles to it depending on which state you're in. But generally, you want to state what it is that you're protecting. You can do that in the actual non-disclosure form or as an attachment to it. Also, you want to have provisions in there saying that the person who's signing it cannot utilize this information in the manner in which you prescribe. Also, if there is a dispute, what's very important is that you set forth what are the remedies and how you're going to mediate the situation, whether it's in state court or arbitration.